Hello, everyone. Thank you very much for joining us. We are going to be getting started on our manufactured home tenancy laws here in just a minute or so. It's 1:30 now, according to my clock. So I'll give it another 30 seconds to a minute to let people get pulled in here, and then we'll get started. Just a heads up that this is going to be recorded and will be available on our website later on. But we are going to be, again, for those who are just coming in, talking about manufactured home law today. All right. I'm just watching my participant counter slow down a little bit, which is great. So I think then at this point we are ready to get started. So I will go ahead and get us going here. Again, thank you for coming to our April session of our ongoing series with our webinars on tenant landlord law here in Minnesota. For those who may not be familiar, Homeline is a nonprofit organization that provides free legal advice to tenants across the state of Minnesota. We've advised over 315,000 renters since 1992. We do offer our services in 4 languages. Spanish, Somali, Hmong, and English. We also have an email and attorney option. These are those contact numbers here on the slides that you can see. So if you are a tenant in Minnesota and you have questions specific to your situation, feel free to give us a call and leave us a message or an email. Couple of things to note. Upcoming webinars. We have the next 2 ones scheduled already. So May 15th, in just over a month, we are going to be having kind of a discussion on impacts of the new eviction laws on courts. So we will have a referee and someone from the judicial um, wow, I just lost that word. Basically, the judicial division will be coming to talk about how the new laws that were just went into effect at the beginning of this year have impacted how evictions are done in the courts. And then in June, we'll be going over the 2024 legislative session recap. So anything that got passed that relates to Minnesota tenant landlord law, we'll try and touch on in that session. You can go to our website, homelinemn.org, to find the registration links for those sessions, and I encourage you to show up for them. A couple of housekeeping things just for our session today. As you probably heard when you came in, this session is being recorded and is going to be available on our website in a few days once we get all of it off of the cloud and uploaded and all that good stuff. So you can access it then. We will also have the slides available in a PDF version once we get that up there as well. If you have questions, which we absolutely encourage questions, love them, you can ask them in the Q&A function, which is located at the bottom of your Zoom window. So it's got the 2 little speech bubbles that said Q&A. Please use that, and because if you put something in the chat, it is very likely that I am not going to see it. I'm going to miss it because I will be putting in links and additional information into that chat. So it is very likely that I'll see it. I will feel badly that I missed your question, but I could have a better chance of seeing it and keeping track of it if it's put into the Q&A function. We will be applying for most likely 1.5 standard CLE credits for this if you are an attorney that needs to get that sort of thing. So that number, the course number, will be sent out to you once we get it from the office of the CLE folks. All right. I will now pass it along to our lovely speakers today. Both of them are housing attorneys here at Homeline. We have both Matt Eichenlaub and Samuel Spade will also be jumping in here in a little bit. But first, I'm going to turn it over to Matt, who is going to start us off. All right. So thank you so much, Matt, and take it away.
All right. I don't often get described as lovely, so thank you. I appreciate it. Yes, my name is Matt. I'm one of the attorneys here at Homeline, and we're going to talk about manufactured home tenancies. It's a complicated area of law, um, and so we'll do our best to talk about it. I've got a couple numbers here: 504B versus 327C. I think this is really where the discussion starts because manufactured home law is very similar to general tenancies, but also very different. And so I sort of refer to them by their statute chapters. 504B is really the bulk of landlord tenant law in Minnesota, and that's the chapter that it's located in. And that covers things like renting a home, renting a house, renting an apartment, renting a condo or a townhome, right? That's 504B. 327C is the chapter that contains a lot of the rules that deal with manufactured homes or mobile homes, is what we don't really call them that much. Mobile homes, we don't call them that much anymore. But 504B really covers all of it. Any sort of residential tenancy is governed by 504B, and 327C offers a few more protections for tenants. Mostly it's more protective of tenants. And there's a couple other exceptions, but one major exception, major-ish exception that we'll get to. And so it's important to know, right? 504B, that's going to cover issues like repairs, um, late fees, the eviction procedures, rent escrow actions, privacy rules. And then the 327C again is very specific to manufactured home with extra protections. Why would manufactured homes have more protections? Well, they're viewed as a longer term living situation. There was an article that ran in the Star Tribune on Sunday, I think, that talked about manufactured homes, and it really got to the heart of it, about why manufactured homes are different than moving into an apartment. Um, the tenant in a manufactured home situation will purchase the property. The home itself is purchased, and then what the tenant rents is the ground underneath it. They rent that from the park. And so the tenant has this significant buy-in. There's usually a loan, there's some title stuff, right? And so there are more protections for the tenant in that sense because they have more buy-in, and moving is very, very difficult. Moving is very difficult anyway, but now it's very, very difficult when you have this greater investment, what is expected to be a longer term living situation. And when you've got this home that is, a mobile home, but it really is not mobile at all. You can move these things, but it costs, I wouldn't be surprised to see $5,000 to move a mobile home, and you have to have somewhere to move it to. So that's the why, right? I think that landlord tenant law is always going to be a balancing act between, the landlord's interest in this property that they own and the tenant's interest in this property that is their home that they rent, but it's their home. And so what we see is sort of this balancing act. And right now, where the balance is there's more protections for a manufactured home tenant, mobile home park tenant, when they own the home and rent the lot. I think it's worth noting that there's a distinction that sometimes a manufactured home park can be, thank you, $10,000. I had someone tell me $8,000 a few months ago, and it sounded high, but $10,000, thank you. That's good confirmation. We're always learning. You need cranes, you need trucks, you need trailers, right? It is the thing itself has to be structurally sound enough to move. So there is a distinction between manufactured home park tenants themselves. When you own the home and rent the ground underneath, you are a 327C tenant. In some situations, a tenant might rent both the home and the lot. In that case, they're a 504B tenant because they're renting essentially everything, right? That's the distinction, is that owning the home and renting the ground underneath, or renting everything. So interesting little distinction. We talk about the bundle of sticks back in property class, right? And so I won't belabor that anymore. Let's go to the next slide. All right, so let's talk about applications. This is really beginning at the beginning when it comes to tenancies. If you want to move into a mobile home park, a manufactured home park, you have to buy the manufactured home, and like any tenancy, you have to be approved by the landlord to be a tenant. This really falls into the category also of what are called, the jargon for it is in-park sales, where you buy a home in the park, in the mobile home park. There are some more particular rules for application fees in 327C than in 504B. First of all, application fee is limited to $25. That's not the case in a 504B scenario. The others are mostly the same. Disclosure of written application criteria. Before the landlord accepts the application fee, they have to disclose why or why not you will be rejected for the property. I think that's something a very much a fair warning statute, so the tenant knows, okay, I know if I have an eviction on my record, I know if I have a criminal history, I have an idea of what my credit score is, and so it's sort of this fair warning thing. An answer is required within 14 days. I think the 504B requirement is reasonable. So 14 days is a very yay or nay, right? Up or down. And the tenant is entitled to an explanation of their rejection. So I think that's important for the tenant to know. This is important, right? You can't just go, a tenant won't just go and buy a mobile home, spend tens of thousands, sometimes more than that, on a manufactured home, and then move in without knowing if they have permission or the landlord's approval to move in. So the application process is sort of set up to guard against that, so that the tenant isn't taking on this huge loan. They aren't taking on this huge burden of purchase until they know precisely whether they're going to be approved for tenancy. This applies to whether the tenant is bringing their mobile home, their manufactured home in from the outside, or whether more common is that they're buying a home that's already established in the park. At 327C.07, that is that statute. All right, let's go to the rental agreement. I say manufactured home, I say mobile home. I sort of go back and forth in my own sort of mind on which one I say, and I don't really know which one is preferred or more accurate. We used to have sort of a running, joking debate in the office about, well, isn't every home a manufactured home? Even a house is manufactured in its way. And I think we finally arrived that a cave would not be a manufactured home. That's really not relevant to the CLE, though, is it? Okay, rental agreements. This is a lease, right? There are some specific rules about leases in Minnesota, and especially in 327C. It must be in writing. This is different than in 504B. In 504B, you're allowed to have sort of this, oral contract, right? Something that could be as informal as me saying to, my brother, go ahead, move into my spare bedroom, $500 a month, pay me on the first. He says, okay, great. That's a deal, right? That's a contract. Mobile home parks, manufactured home parks needs to be in writing. And so that's different. So that's, as an attorney, right? I, as an attorney, I prefer things in writing, because then everything is written and everything is laid out in front of you. And so I think this is just good business to put it in writing. But yes, the contract must be in writing. The statute states the applicant must have a chance to review it. Again, 504B, it isn't so specific as that. That's good business, right? Only sign things you understand, only sign things you agree with. But here it's really sort of specifically laid out. There are some very particular required terms it needs to include. I'm not going to get too far into that. You can check out the statute and look at those things. Some of them have, so that's worth noting, taking a look at. And then a copy must be given to the resident. That's sort of what I think of as kind of a fair play situation. That is mirrored in 504B. And again, it's said here in 327C. But yeah, everybody should have a copy of the rules. Everybody should have a copy of the agreement. That's just good business also. And that is my slide on rental agreements. I pass it over.
Well, hello, everyone. My name is Samuel Spade, also one of the staff attorneys here at Homeline. And I'm going to be talking through a number of different slides here, but I'm going to be starting with rule changes and rules just more in general. So Matt just got through talking about leases, and a lease governs the park and the residence agreement, but there's also often in mobile home parks rules or addendums attached to that lease. And frankly, the definition of rule, which I have here on the slide, this is a direct quote from 327C. Any rental agreement provision, regulation, rule, or policy through which a park owner controls, affects, or seeks to control or affect the behavior of residents. I mean, that's so broad that it basically includes almost everything. So a rule includes not just things in the lease, but the rules or attachments, addendums, park rules, handbook, etc., whatever they're called, that the park expects the residential tenant to follow. Next slide. To start with, then, let's talk about unreasonable rules. So unreasonable rules are just prohibited. This is under 327C.05. Sorry, you might see me glancing over at the rules. The advantage of doing this remotely is I can have all of the rules up in front of me and refer to them. Unreasonable rules are just prohibited. A landlord or park owner, to use the language of the statute, cannot adopt or enforce unreasonable rules. This is true for rule changes. It's also true for the the original lease and rules. There are some presumptively unreasonable rules, which are listed in the statute. They mostly include things about sales, like you can't prohibit the placing of a for sale sign or require the resident to use a particular dealer or broker in an in-park sale, things like that. There's also, though, under subdivision 3 of 327C.05, sort of a catch-all, which says any unreasonable rule, or an unreasonable rule includes any rule which isn't reasonable. It refers back to 327C. 0.015 subdivision 12, which is the definitional section, and that's on our next slide here. So a reasonable rule under this definition, I greatly summarize this. There's actually a little bit broader than what it looks like here, but essentially it's any rule which is designed to promote the good of the residents or the good of the park premises. Notice I say park premises. It's not the good of the landlord. It is the good of the park premises or the facilitation and efficient operation of the park. But a reasonable rule is not something that just promotes, the park owner's bottom line or something like that. It's the good of the residents, the good of the park premises. The rule also has to be reasonably related to its purpose, and it can't be retaliatory or discriminatory, and must be sufficiently explicit to sort of tell the tenant what they are supposed to do or not do. So an example of this are certain types of parking rules. And parking rules could, of course, be unreasonable, but obviously most parks, they've got streets running through them. There's probably going to be some rules about where you can and cannot park. That's, for the good of the residents or the good of the park premises, allowing people to use it as long as they're not retaliatory or discriminatory, sufficiently explicit. Those types of rules are probably allowed. Also, rules about maintenance are pretty common, rules about conduct on the premises, all of the things that you would normally see in a lease. Often can be a reasonable rule. Again, it just depends on whether or not it meets these requirements. So if you can have reasonable rules, can you change those rules? And actually, this is already a question we see to the panelists. Tenants can never be forced to sign a new lease. They essentially have endless leases. We'll talk a little bit more about why this is the case when I get to evictions and notices to vacate. But for now, just take it on faith for just a few more minutes that a tenant can never be forced to sign a new lease. They have endless leases. What a landlord or park owner can do is change the rules. If they want to change the rules, they can give a 60-day notice in writing of that rule change. Goes out to the whole park. Obviously, a landlord can't just target an individual tenant, but they can give a rule change to the whole park with 60 days notice in writing. That rule must be reasonable. So the new rule must be reasonable. And most importantly, for existing tenants, it cannot be a substantial modification of the rules that currently apply to them. So if a landlord wants to impose a rule and it's reasonable, but it would substantially modify a current tenant's lease or their rules, and I'm going to try to remember to say lease or rules because it really is both. It's not just that the lease is the tenant never has to sign a new lease, that whatever the document title lease that the tenant has is, but the landlord can change the rules attached to that lease at any point. As we covered with the definition of rule, the rules basically cover everything, the lease, the attachment, it doesn't matter. So both of those things, regardless of what they're called, the lease that the tenant has and the park rules they're there for the tenant, and they can never be changed for an existing tenant unless it is both reasonable and not a substantial modification. And what this means is that different tenants will have, I say may have, but in a long enough time span, it's pretty much always will have different rules. Tenants get grandfathered in. So if a tenant comes in to a park and the rules are they can do the following things, I'll just try to pick an example. Let's say the rule is they can have a trailer or something on their lot, or a pool on their lot. Well, actually, we got that question. We'll talk about it maybe a little bit more later. And the landlord wants to change that rule and say no trailers, no pools on the lot. That could be a reasonable rule change. It would, again, all of these things depend on the exact facts, but there's a way to make that a reasonable rule change. The landlord can send out that written notice. They can change the rules. It will apply to everyone who moves into the park, but for the tenants who are already there, they get to follow the rules that they had when they moved in. Again, unless the rule changes reasonable and not a substantial modification. Landlords don't like this rule, and they don't like it for two reasons, one of which is legitimate. The legitimate reason is that it does make managing parks slightly harder than managing apartment complexes in some cases, because landlords have to track the different rules that apply to the different tenants. And you might have, again, tenants live in mobile home parks 20, 30 plus years. You might have a lot of different rules that apply to different tenants. And sometimes this can cause problems even between tenants where, tenant A gets to do something because they've lived there for 20 years that tenant B doesn't get to do. But, that's sort of just what it means to live in a mobile home park. At least in my personal opinion, illegitimate reason to like this is that, frankly, a lot of times when landlords want to change rules, they just want to take away the tenant's rights. They want more control over the tenant and the tenant's property. And as Matt discussed at the start, mobile homes give people more protections because the mobile home is a larger investment. It's harder to move. Maybe other reasons. In some sense, it doesn't matter. The laws were written and they simply have more protections. It's harder to change the rules that apply to them. So landlords can't come in and just take away the rights that tenants have, which brings me to rent and rent increases. So rent is a little bit different from the rule change. It's kind of its own thing. It's got a couple additional rules, but it's fairly similar in some ways. Rent must be uniform throughout the park, just like the rules have to be uniform throughout the park in general. Except that with rent, you can consider the different size, location, special services that may be. So some lots may be bigger or have access to different amenities or something along those lines. And in those cases, the rent might be different for the lots that have those special features. You cannot have special fees. In fact, this is, I think, important enough that I'm just going to read it from the statute. So, except as provided in this section, in section 327C.04, which governs utilities, no fee other than the periodic rental payment shall be charged to a park resident or prospective resident or any agent of a resident or prospective resident for the right to obtain or retain a lot. Essentially, you get rent. The landlord gets to charge rent, the tenant has to pay rent, and utilities. Those are the two things that a tenant can be charged. Obviously, there are other things a tenant could be charged for. For example, if they damage something, they could be charged to replace it or something like that. But in general, it's rent and utilities, and those are really the only fees that a tenant can be charged. Courts generally tend to be okay with charging late fees on rent, which I don't know. Part of me wants to say I think it violates the special fees, but I don't think there's any case law on that. And just in general, courts let landlords and mobile home charge late fees. So that is something that is allowed, maybe a sort of a subcategory here. Rent can be changed just like rules with 60 days written notice. Again, it goes out through the whole park. The one difference here, the one additional protection here is that you can only have 2 rent increases in any 12-month period. And actually, Matt will talk a bit more about this at the end, but there was just a rule change with regards to utility changes. But in that case, it's 1 rent increase in any 13-month period. But generally, rent increases can only happen twice in any 12-month period. Other rules could be changed every month with 6 months notice, or sorry, 6 months, 60 days notice. Next slide. So change of ownership. As you might have actually figured out from this point, I see a couple questions, which I think we'll deal with them in a bit more direct. We'll deal with the questions a bit more directly here towards the end, but this will probably answer a couple of them. Changes in ownership don't really affect that much, legally speaking. Practically, of course, it can affect a lot. You're dealing with different people, you're paying rent to different places, they might have different management styles, etc. But legally, it doesn't really change that much for the tenants. Tenants, as we already discussed, they cannot be required to sign new leases. They cannot be required to sign new rules. Again, we often use these words differently and they sort of have different purposes in some way, but legally they're mostly the same thing here. Tenants cannot be required to sign new leases or new rules or anything like that. New landlords can change the rules and increase the rent, but only if they follow the state law regarding rule changes and rent increases that we just went through. So they can give 60 days notice for a reasonable rule change. They don't actually need the tenant to sign anything. Again, they can't force the tenant to sign a new lease on new rules. They can just change them, but the old tenants get the old rules if the new rules are going to be substantial modifications. And this happens a lot. And the Minnesota Attorney General has gone after landlords who have done this. Tenants have gone after landlords themselves for this. It is a big problem, a big area of contention. But new landlords don't just get to force tenants to sign new leases or change the rules of the rent. They've got to follow the laws that we just covered. And can we get the full slide up there? There we go. The reason for this, so if you've been wondering, why do I keep saying they're endless leases? Why do I say the tenant can't be forced to sign a new lease, et cetera? Well, one is all the statutes that we just covered with regards to how rules get changed. But the other is simply that notices to vacate without cause are invalid. There is no way to give a tenant a notice to vacate because they're, for example, on a month-to-month lease, or because they're on a 1-year lease or something like that. And again, what Matt said this, and I should clarify this, everything we're talking about here only applies if the tenant owns the home and rents the lot. You do occasionally have pure tenancies, pure residential tenancies in mobile home parks, where the person living in the mobile home is renting both the home and the lot. They might be renting both from the park owner. The park owner might own the home and be renting both of them out, both the home and the lot, to the tenant. Or they might be renting the home from one person, and that person might be renting from the park, or the tenant might have dual agreements, which can get confusing, but does occasionally happen. However, assuming that the tenant owns the home and rents the lot, there is no way for the park to simply terminate the lease. The tenant could terminate the lease. It might be a month to month, it might be year to year, something like that. The tenant could terminate the lease if they want to move or sell or take the home with them or something like that, but the park owner cannot. The only way to terminate the lease is under 327C.09, which is basically the eviction statute. And I'll talk in greater detail about that in just a moment. Or if the park itself is closing, which we're not really going to cover in depth. But as you can see, if the only way to terminate a lease is by an eviction case, and we'll talk about what's covered, but one of the things that is not included is just pure notice to vacate or holdover. If the only way to terminate is basically for cause, then there's no way to actually make the tenant sign a new lease. So the tenant can simply say, no, I'm not signing the new lease, I'm not moving out. And if you want to change the rules, you can change the rules, but you have to follow the requirements of 327C, no substantial modifications, notice, and all of that. So there's no way to give a notice to vacate. So there's no way to force a tenant to move or sign a new lease. unless there's good cause. So there's just no way to make a tenant sign a new lease. Next slide. So this brings me to evictions. Evictions, actually, you know what? Can I stop here, Rachel? Do you have any issue if I do that and we go through a couple of the questions that have already been asked?
Absolutely no problem with that.
Okay, so
Oh,
one of the questions
mhm.
was talk about month-to-month self-renewing leases, especially when a corporation buys the park and tries to impose a new restrictive lease on current residents. I think we've answered that one. They simply can't. They can't force the tenant to sign a new lease. They can't give them a notice to vacate. They can change the rules, but they have to follow the requirements of rule changes. They have to be 60 days written notice, reasonable, not substantial modifications. And again, especially with changes of ownership, what you really do get is you get into the situations where there are different rules because the park owner comes in, the new park owner comes in, they want to change all the rules, and they can change those rules for new tenants, for tenants coming into the park. So then you have this case where the new tenants, the tenants coming in, have one set of rules, and older tenants would have a different set of rules. One quick practice pointer there for either, really regardless of who you are in this, whether you're a park owner, a residential tenant, an attorney representing either side, you really want to keep copies of the leases and the various rules that have existed over time. I think especially if you're a tenant, this is very important. You can't expect a landlord to do it. They should, but they don't often. So you want to keep a copy of your rules. You want to keep a copy of the rules that apply to you. And every time you get rule changes, you want to keep those as well so you can track over time which rules sort of apply to you and which don't. Because landlords will definitely pretend that this law doesn't exist and that you have to comply with it. They do it all the time. And again, they get sued for it too. So it is possible to resist, but it does require some diligence on the part of the tenant. So we got that question.
Yeah.
I think one of the questions that what came in prior to this was the notice to vacate question, which I think sort of is exactly what we just talked about. Is something like changing the method of rent payment a substantial or significant modification? It could be. It does depend on how it's happening. I mean, for example, this might be a little bit silly and probably not what the person who asked this question intended, but if they are saying you used to pay at this drop box and we moved the drop box across the park and now you have to pay at this other drop box, I mean, that's not a substantial modification. I think, really what the question is getting at is you must pay entirely online. We no longer accept checks. We no longer accept cash or money orders. I would say often the answer is yes. Some of this depends on what's written in their initial lease. This gets a bit tricky, but if a lease gives the tenants certain rights, then it does make it harder for them to be changed later on because it would be a bigger substantial modification, taking away a right that they already have. Some of it also could depend upon, again, what the landlord wants. Is it online and offline? Can the tenant choose, or are they mandating one or the other? How easy is it for everyone? Because, again, I don't, there's probably, I don't actually know if there are any mobile home parks in Minneapolis directly where there is sort of free Wi-Fi, but the farther you get out where internet is less reliable, people don't necessarily have uh, computers, frankly, in some cases, or access to the internet in the same way, it might just be unreasonable to expect that. And so it could depend on the situation of the park as well. So short answer, in many cases, yes. In some cases, no. It would need to be dealt with on a case by case basis to see how much is actually, how much of a burden it essentially is in that specific instance.
Classic
Um,
legal, classic legal answer. It depends.
yes, it does depend. I think though, really here, that is a big deal with this because a lot of this, these terms like substantial and reasonable, they're not well defined on purpose. They're left up to sort of a gray area so that there's things aren't over regulated. But that does mean sometimes you get into arguments and you've got to go to court to have a judge resolve it if you can't. Someone pointed out that I made a mistake, which is correct. There is a $4 pet fee. So that is one of the exceptions to the no special fees. Thank you for
That
reminding me of that.
that's per
Uh,
month, right?
yes, per month. Um, let's see. Then there was a couple questions that were put in before this started that I wanted to answer as well.
Sure.
So there was a question from Tenant about putting a pool back up, adding it for years, nothing in lease or reg says I can't have one. That's probably a bit too specific for me to answer directly here. You could certainly, if you're a tenant, call our hotline or send us an email and we could reply. But my guess is, based upon sort of what you're saying, that it would fit within the substantial modification uh, framework, and it would depend on what rules you had when you first moved in and what they changed the rules to and how much of a right that took away. Was there a good reason for it? So again, that's where you get into the analysis of what are the actual facts. And if you contact us, again, email or by phone, it's definitely something that we could talk about with you. Um, if a person, sorry, why won't, this is another tenant, why won't they let you have a privacy fence? Again, I can't tell from this question, so if you're in the presentation, feel free to ask a more detailed version. I can't tell from this question if this is talking about a rule change or if this is talking about sort of a rule that you're like just coming into the park. I definitely think, well, I shouldn't say definitely. I think it is very likely that as an initial rule, it would be okay for a landlord to forbid privacy fences. It seems like there could be a number of reasons based upon how the park is set up for that to be a reasonable rule, for that to be something good for the park, good for the residents, at least in general. If it's a rule change, as in there is a privacy fence already and the landlord is coming in and saying you have to take it down, I actually think that would almost be presumptively unreasonable. The landlord would have a pretty big hurdle to get over to say why that isn't taking away a substantial right that you as the tenant have. Um, Especially if they're trying to say you have to do it on your own dime, because then that costs money, which is another thing that makes rule changes unreasonable. And then there was another question relating to rule changes. Can late fees be increased through 327C rent increases, or would that be a substantial modification under 327C.02? The answer to this, I think, depends on what currently exists. If the lease does not have a late fee in it to begin with, then I don't think that a landlord can add a late fee for those tenants down the road. I think that would be a substantial modification, would be adding fees, which if you look up the definition of substantial modification, one of that means involving a significant new expense for a resident. And there is court cases on this. I can't remember the citation off the top of my head, but when you go from no late fee to late fee, that's going to be a substantial modification. The trickier versions of this is what if there's already some type of late fee in the lease. If there's an 8% late fee in the lease and the rent goes up, but the late fee remains 8%, I don't think that's a substantial modification. If the late fee is $5 and they say, all right, we want to up it to 8%, and that's going to be like now 40 or 50, maybe it is. That's where I think, again, you really get into questions of like, is this a substantial modification? If the tenant and the landlord can't agree, someone's got to either pick a side, or you end up going to court and letting a judge decide whether or not this is a reasonable rule change and whether or not it counts as a substantial modification. I think there was one more question here. Give me a moment.
And we have many more questions, but these are the specific ones
Yes,
for
yes,
what you
sorry.
had. Yeah, I should make it clear. Like I will be asking those questions as well at the end of our presentation. So if we haven't gotten to your question yet, don't worry, we will get there. I promise.
Yeah. So I just want to answer the questions that
Mhm.
relate to rent increases and reasonable rule changes right now. Would changing size of the lot be a reasonable rule change? Like, again, I don't know if they wanted to take off like 1 foot for like some type of sidewalk, maybe, but I can't imagine that being a reasonable rule change in most cases, just taking away the tenant's like part of the tenant's property. I again, I'm going to say this as Rachel said all the time. These are the rule is reasonable, so you have to. There's always going to be some gray there, but I just can't imagine that being reasonable in most cases. I think that covers the current questions that really relate to this.
Correct.
Um,
And again, if we miss some, that's fine. We will be um, we'll be coming back through them again, at the end here. So um, you can pause, take a breath, get some water in you if we want. Unless there's anything else that you wanted to mention about this.
no, are you saying we're going to take a break here,
No,
or we're
we're
going
gonna
on to evictions?
going on to
All
evictions.
right.
But if you
So
wanted to have some
evictions.
water, that's fine.
So evictions. So there are more questions, as Rachel said. We'll come back to them, but for the moment, I'm going to start talking about evictions. The evictions are mostly covered by the following three statutes: 327C, .09, .10, .11. 10 is defenses, and 11 covers the evictions proceedings. So it's really the main statute to look at is 327C, .09. It lists the reasons that a park owner can terminate the lease. And what it says right in subdivision 1 is that a park owner may recover possession of land upon which a manufactured home is situated only for reasons specified in this section or 327C .095, which is a park closing. So basically, the only way to terminate a lease, the only way the landlord can get the lot back, because again, this applies to people who rent the home, or sorry, own the home and rent just the lot, is for one of the reasons listed in this statute. The first is non-payment of rent or utilities. The park owner under 327C .09 has to give a 10-day written notice of any rent that's owed, and they have to give this both to the resident and to any party holding a security interest. However, under the new Minnesota state law, 504B 321, subdivision 1A, the landlord has to give a 14-day notice. So basically, the landlord has to give a 14-day notice here. But the one thing that is still true under 327C .09 is that they have to give the notice with at least 10 days notice to any party holding a security interest in the resident's home, if that is the case, which it can be in a mobile home park. If the tenant doesn't meet the requirements of the new 14-day notice to pay or quit, the landlord can then file an eviction for non-payment. Just like with non-mobile home or manufactured homes, the tenant has the right to redeem, but this is our one exception where tenants actually have a little bit fewer rights than they do under normal landlord-tenant law, normal residential landlord-tenant law. Under a normal, say, an apartment complex or renting a home or anything like that, tenants can essentially redeem every time. In fact, we've seen this. There was one case years ago where, and frankly, I don't know how this worked, but the tenant paid rent late continually, and the landlord filed eviction after eviction. I think within 1 year, the landlord filed 6 evictions against the tenant, and the tenant redeemed every single one. And I don't know how they had the money to redeem and pay the court fees when like they weren't just paying rent on time. Maybe they just got into a bad cycle, but they redeemed, and they're allowed to. A tenant is allowed to redeem in a mobile home. However, the right of redemption is only available twice in any 12-month period, except that they can redeem more than 12 times, but 2 times in a 12-month period. But after that, they have to start paying the park owner's actual reasonable attorney's fees as part of each additional exercise of that right. Whereas in just 504B 291, the tenant only has to pay $5 for attorney's fees to redeem. And that can be a very significant exception. Obviously, it doesn't apply in that many cases. Hopefully, for both the park and the tenant is not getting multiple evictions on them filed in the same year. But if it does happen, they, on the third time, can only redeem if they're also going to pay the attorney's fees. And in those cases, that's a very significant additional step that the tenant has to do if they want to redeem. So it's the one case where tenants really do actually have a little bit fewer rights or a less of a right when they own a mobile home. The next reason that a landlord can file an eviction, sorry, I should have listed all these on the slides, they just didn't have space, is for a rule violation. the landlord can file an eviction for a rule violation, but if they want to do that, they have to give the tenant a 30-day notice of the rule violation and give the tenant a right to cure within those 30 days. Essentially, the tenant gets a chance to stop doing whatever it is. And for that notice to be effective, it has to be fairly specific. It has to specify the date, the approximate time and nature of the alleged rule violation. For example, loud noises or a violation of some type of parking requirement or some type of home maintenance requirement or something like that. They have to give the tenant the right then to cure, and if the tenant cures, they don't get evicted. If the written notice has been provided twice before, then well, this is a subcategory for loud noises, but then it can be moved into a repeated serious violation, or some type of, well, actually, I'll cover that separately, sorry. So if it happens multiple times, it can become a repeated serious violation, and then there's no right to cure. So the landlord can just go file an eviction. And then there's also a separate carve out for the endangerment or substantial annoyance. If the park resident acts in a way which endangers other park members, park personnel, or something like that, causes a lot of damage, they can just be given a 30-day notice to vacate. In some cases, it can even be immediate, and there's no right to cure. That's the one exception to the right to cure. Otherwise, tenants generally have a right to cure, fix the violation, and not get evicted. Again, there's also repeated serious violations where if they keep having the same rule violation over and over and over again, they lose their right to cure and can be evicted as well. There's a couple other categories that don't really come up. There's material misstatement and application or improvements to the land. Frankly, I don't know if I've seen more than one of either of those. They just happen so frequently, so infrequently. They're not really on our radar. So obviously what you have here is the same you have three categories for evictions: non-payment, some type of breach of lease where you have a right to cure, and then endangerment or substantial annoyance where you don't have a right to cure, which track pretty closely to evictions for non-payment of rent, breach of lease, or violations of 504B.171 that you have for other types of residential tenancies. But notice that what you don't have is you don't have just a holdover. You don't have any ability to terminate a lease as a park owner just because the lease is over or it's month to month or something like that. It's not included in this list, so there's no way to do it. The next thing to talk about with evictions is, let's say the tenant loses. If the tenant loses, they have to move just like normal, but they own their mobile home. So there is one additional thing that a tenant can do in an eviction where they lose their mobile home, and that's they can ask for a conditional writ. Basically, what they do is they ask the court for, sorry, one second. They ask the court for a conditional writ, which allows them to keep their home on the property for 60 days for the purposes of an in-park sale. They have to pay all the rent during this time period. They have to follow all the rules, and they aren't allowed to reside. So basically, the home just sort of sits there while they try to sell it. This doesn't happen very often because most evictions are for non-payment of rent, and one of the conditions of the conditional rent is that the tenant continues to pay the rent, which if they're behind on rent, they might not be able to do. But it does happen occasionally. And so in those cases, the home might sit there for an additional 60 days. Otherwise, the eviction process, the process of removing a tenant from the home or forcing a tenant to move when they lose the eviction is the same whether they live in the mobile home park or whether they're renting in an apartment complex or a single family home or something like that. The landlord goes to court. The landlord, if they win, they get a writ. The writ goes to the sheriff. The sheriff posts it on the door of the mobile home, and after 24 hours, at least 24 hours, often it's longer, the sheriff can come back and forcibly remove the tenant. Now this might, you might guess, lead to another major problem or difference between a tenant moving from a mobile home park and a tenant moving from an apartment complex or from a single family home or something like that, which is that you have the mobile home, which is owned by the tenant, which is still on the property. In theory, the tenant can just pick it up and take it with them. But as we've already discussed, that can be thousands, over $10,000, $8,000. I've seen different numbers thrown out here in the chat and in the questions. It can be a fair amount of money. If the tenant wasn't paying their rent because they didn't have the rent, they probably don't have an additional $8,000 or $10,000 to actually move the home, which means that almost never happens. The home doesn't get moved, which means the home stays there. And so then the question is, what happens? Well, the tenant might be able to get a conditional writ and sell it, or maybe can even sell it without the conditional writ within just the normal time period. But often they cannot do that. Often the home simply sits there. And then what happens is the landlord has to follow 504B 271. This is the statute that covers abandoned personal property. Which is a little bit weird. Again, normally the statute is covered or is used to cover things like a sofa or a bed or those types of things. Here, it's the whole home. But it does still apply, at least as far as we know. We've never been informed of any rule that says it doesn't. I'll look at chat here and see if someone is saying anything that I've missed in my practice of law here. But the difference here is that because the home has some value, often a couple of things happen. Number one, under 271, the landlord is not likely to throw the home away. They might. In some cases, the home might be in such a condition that it is easier to just trash the home than to sell it or keep it for themselves and re-rent it. But often what they're going to do is they're either going to sell the home to someone else who wants to come into the park, or they're going to keep it and re-rent it. In both of those cases, they are taking control of the home, which effectively means that they have to follow 504B.271, specifically subdivision 1C and D. They can sell things, but they have to give the tenant notice. They have to apply a reasonable amount of the proceeds of the sale to any costs that the tenant incurred or that the tenant owed them, which often means that at that point, the tenant might not owe them anything for rent or anything like that. And in theory, any remaining proceeds of the sale shall be paid to the tenant upon written demand. I have never seen this happen. I asked Matt. I don't think he's ever seen it happen. My guess is there's probably something out there for some tenants, but I think a lot of times the amount of rent owed is either too high or, there's enough other debt or the home might not be worth enough that what generally happens in our experience is a landlord and tenant just sort of consider it a wash. The landlord doesn't come after the tenant really for anything, and the tenant just leaves, and that's the end of it. Whether or not this is fair or right probably depends on the value of the home and a couple other things, but from our experience, that's what we've seen most of the time. And with that, let me see. Let me take a quick look here and see if there are any questions on the stuff we've covered so far. Rachel, if you see any, let me know.
Will do.
I see a note from Tim Bellin that because the trailer is titled, property owner is better off using a sheriff's sale statutory process.
Yeah.
We do often see that as well. Or we do, I shouldn't say often. I don't know which I see most, but you do see that. And there was also a note about the tenant redeeming, yes, that they keep paying. And so it can be done. You just increase the amount, or the tenant asks to cover the attorney's fees.
Tim earlier also had a question about if a tenant abandons the manufactured home just outright, does it follow the 504B.271 at that point then?
We don't see that a whole lot, but yes, I think the answer is it could. If they abandon their property and they really don't do anything, then at some point it turns over to the tenant. Now, this gets you into another question, or sorry, it turns over to the landlord or the park owner. This gets you into another question, which is just what counts as abandonment. For the sake of answering that question, we'll just assume that the tenant did abandon it. But obviously, especially with something that can be as valuable as a mobile home, assuming that the tenant abandoned it is a very possibly dangerous situation. Because if the tenant really didn't abandon it, and the landlord just takes the home tries to resell it or just let someone else live in there, or in a worst case scenario, destroys the home because they don't think it's valuable or something like that, the landlord could be on the hook for very, very high damages. You get triple damages effectively under 504B.271. If it qualifies as a lockout in bad faith, you get triple damages. You get reasonable attorney's fees under both of these things. So my caution for landlords would be that assuming a tenant has abandoned the home is dangerous. If I were representing landlords or park owners, would never assume that without something explicit from the tenant saying, I have abandoned the home, or this is my notice to vacate, I don't care what happens, or, maybe if not that explicit, something along those lines. Let's see, are there any other questions here? Can park owners prohibit tenants from smoking cannabis? This is related to both the rule changes and the evictions.
Sure.
The answer is yes, assuming that it's a reasonable rule change or that it's already a part of the lease. A lot of leases might already prohibit smoking of certain kinds. Note that the cannabis laws only allow landlords to prohibit smoking and vaping. So actual use of all cannabis or marijuana products, the landlord can no longer prohibit. But if the lease already did it, or if the landlord can make a case for it being a reasonable change, then they could. And there's also, outside of landlord tenant law, there is the ability to sue neighbors for being nuisances with marijuana. So in like very extreme cases, and I do want to be careful there, but in very extreme cases where it's causing a problem for the whole park, there might be other remedies as well. So I'm just going to keep looking here. Rachel, let me know if I've missed any.
I have one from the pre-submitted questions, but I didn't spy any in the current Q&A.
Okay, I do see one here. What's the pre-submitted question?
Carla, who's a tenant, just wanted to know briefly what their rights were after they got evicted. Can the landlord just take the home and change the locks? And you kind of went over that timeline at the very least.
Yeah, it does depend a bit upon what happens, but if there's no conditional writ, then the landlord can change the locks, and when the sheriff comes out to enforce the writ, so they can do it with the sheriff there, but they have to get that writ from the court. They have to post, the sheriff has to post it on the door. The sheriff has to wait 24 hours and come back. Even after that point, the tenant can still get the property. So the other way that 504B.271 applies is it does apply if the tenant wanted to go back in to get either personal property in the home, or again, in theory, if they wanted to take the whole home, which just in practice doesn't happen very often. But there is often property in the house itself that the tenant might want. And in that case, the landlord has to follow the rules and requirements around abandoned personal property for that too. So the tenant can give a notice 24 hours if it's stored on site, which in a mobile home it virtually always would be. So 24-hour written notice to go back and get the property, which would allow them to go inside the home, retrieve personal property that was there, and move it out. The home itself, again, that I think we already covered when we were talking about it. So I see a message about cooking meth. That's covered under 327C.09 substantial endangerment, which let me pull that up so I don't make any mistakes here. There is a way to file for essentially an emergency eviction to cut short that time period for endangerment or substantial notice. It's just reading directly from the statute. The park owner may require the resident to vacate immediately if the resident violates this subdivision a second or subsequent time. Maybe I'm wrong about where it is. I'm actually going to take back my answer on that. I thought I knew it, and maybe I'm wrong. So I will look into it more while Matt is talking and see if I can get a more thorough answer. Any other questions that I missed for the eviction portion?
I do not believe so. We still have some, slides left for Matt to get through. We can look through that, and then we can certainly go through any remaining questions
Yep.
at
All
that
right.
point. So, and you can do a little digging. Matt, are you still here?
I am.
Excellent. All right. I think it is on to you.
All right, awesome. Samuel does a great job.
Absolutely.
So I'm going to jump back into some sales, in-park sales issues here. I I was, thinking about sales. There's always a buyer, and there's also a seller too. And so some of these rules apply to, well, these rules do apply to tenants who are looking to sell as well as tenants who are interested in buying. We talked a little bit about in-park sales in the application process slide. And so this is really the tenant buying into the park or selling out of the park. It's important to note you have a right to sell. You own this manufactured home, it's yours, you can sell it. And so these protections in these statutes really aim to make it possible for the tenant to sell. You don't have to use too much of an imagination to think of ways a landlord could make a sale go badly, right? So there's some effort in protecting a tenant's right to sell and a tenant's right to buy. I'll say a little bit about titles right now. Manufactured homes are titled similar to the way a car would be titled. I believe you need to go to the Department of Vehicle Services for any title issues. I think we had some early pre-submitted questions about not being able to get titles. I really can't tell you much more than to take it up with them. There are ways to get replacement titles for cars, so I have to presume that they're the same for manufactured homes. I think that it's important to be cautious when you're purchasing a mobile home, and make sure they have the title. I suppose it's a real hornet's nest to get involved in. But what's important, so back to the statute though, 0.07, inspection of the home. Tenants certainly got a right to the inspection of the home. This is sort of, good practice would certainly be inspecting the home before you buy it. But it's important to say, look, I've got a right to see this also before I put some money down. The statute also specifically states that sales are contingent upon the approval of a tenancy. You can imagine just that nightmare scenario where you plunk down a bunch of money, you take on a loan to buy a home, and then you're rejected as a tenant by the landlord. Now, are you stuck with no place, no home, right? You own a home that you can't live in now? Well, what the statute says is no matter what any sort of payment agreement says, what any sales agreement says, if you're rejected as tenancy, the sale's off. As basically a matter of the statute. You get it, it's over. So that's again another protection for buyers. Okay, let's go to the next one. You can also sell to the park, of course. Sometimes parks want to buy these homes. They might want to buy them to resell them. They might want to buy them to rent out to other tenants. They might want to buy them as a way to clear off some sort of debt that's owed. Again, this goes back to, we don't have to imagine too hard a way that these things can get out of hand for a tenant. So the park can't require a resident to sell to them, right? That's an important thing because I have heard occasionally some parks doing pretty heavy-handed business, right? You're going to sell to us for this reduced amount, whether you like it or not. Certainly not allowed. The park can't require that a tenant use a specific broker. There are some agencies out there that do specialize in brokering mobile home parks, manufactured homes. And so they can't require that. You've got a right to sort of sell it on your own. You've got a right to use your own broker should you need to. But again, this is a chance for bad actors. And so what is the remedy for the tenants if they feel they've been unable to sell the home due to the landlord's action, due to the park owner's actions? I'm not sure. Maybe it's to seek some sort of specific performance. Maybe it's to seek the damages, the money they would have made from the sale if they had a buyer lined up, a good concrete buyer. It becomes very, very difficult for tenants. It becomes very complicated. But it's important to just state that the park cannot require you to use their broker, can't require you to sell to them. You've got the right as a buyer or as a seller to sell. So that's important. Talk about park closings a little bit. We don't see a lot of park closing issues because they don't close very often. There was one notable one in St. Anthony. I want to say 5 years ago, but that means it was probably 8, right? And it is a very complicated situation. It could be its own CLE, as I've noted. But if you want to take a look at the statute, there it is, 327C.095. A couple of the highlights here that are important. The owner's got to give notice of the intent to close. They have to notify the residents, Minnesota Housing Finance Administration, the Commissioner of Health, local planning commissions, a year notice. So this is quite a lengthy notice that they have to give before the park closes, because this is a big deal to have a park close. Residents usually living there for decades is not uncommon, 5, 10, 15, 20 years. I think you get longer term tenants in a manufactured home park than you do in an apartment or even a single family home. Just by, again, its nature is that you buy this manufactured home and that's going to be where you live, right? And so this 1 year, so this is a big deal to close the property, to close the park. There is what's called a manufactured home relocation trust fund. There is a portion that is paid typically from a tenant's rent. It can be paid from that the park then pays to this trust fund, and that if it happened, the manufactured home closes, then the residents can get basically a payout from this trust fund to help them relocate, move the home, whatever it is. The amount that's paid out depends on, I believe, how big the home is. It depends on how long they've lived there. It's a complicated formula, but it's in there, and so it's worth taking a look at. There is some opportunity to purchase. This was a big issue in that St. Anthony incident that I mentioned, and they did change the statutes a little bit in response to that. But on paper, the tenants have a right to purchase the mobile home park and remain residents, probably owning it in some sort of cooperative mobile manufactured home park cooperative fashion would probably be the result. But that's good information to know that they still get the first right to purchase the property. Being able to do that is a different situation, of course. But those are a lot of hypotheticals and what ifs. And so, like I say, park closings really complicated. A lot of big issues involved in a park closing. And as I say, it certainly could be its own CLE. So let's go to the next one. Some new laws. Remember last session, all those changes? There were a lot of changes to landlord-tenant law generally, and manufactured homes are no exception. The big one was this: the installation of water and sewer meters is not a substantial modification under the lease. We talked about that, right? A rule change that involves extra cost to the tenant will often be deemed an unreasonable modification. Changing the water bill from something the landlord has to pay to something the tenant has to pay, well, that's more money out of the tenant's pocket. This statute basically says, no, it's not, right? This is sort of the balance that's been struck under statute, is that it is not a substantial modification. It is something that's allowed for a landlord to do. There were some other changes, somewhat minor changes, involving a lot of things like inspections. I got it written down here, inspecting, like say, the footings, the concrete footings, pipes, and some building codes. Those are important changes, but not changes that I'm really going to drill down into here today. So important, but not really minor for the purposes of this PowerPoint's presentation. And some changes to the notice for unsolicited sales. I think reading the Star Tribune article, I think was very, very interesting, because it is a really interesting capture of what this angle of the rental market that is often overlooked. We've heard for years, maybe decades, right, about how everything is getting more expensive, the cost of rent is going up, and it seems like just like a one-way track. And so how does this affect manufactured home parks is not really something that's been focused on much. And so this this article is really interesting, saying, look, there are a lot of people looking at some value here. These may be valuable things, and so these changes are sort of reflections of that. And that's really my little bit about the new laws. Other
All right.
resources, yeah, this is your slide. I think this is your slide.
Okay. There are other resources.
You can look at those.
Yes. So yeah, there's other, beyond obviously this, Minnesota Attorney General has some resources. Legal aid is another great resource for folks, especially if you are low income. And then Housing Justice Center also has a focus in some of their work on manufactured home parks. All right, so we have about 20 minutes left according to my clock. So I know that we've got several questions still to go. So I'm going to pull both Matt and Samuel back up here, please. Matt, since you brought it up twice, what I was looking for was that Star Tribune article to link to in the chat. So if you can find that and put that in the chat, that'd be great.
Yeah, I think Andrea
And I'm
emailed it
going
to me.
to start going through some of the questions that we got. So as always, I'll start with the pre-submitted questions. One of the perks about having, sending your questions to us ahead of time is that they get asked first. And we sometimes will have a little bit more chance to research. So, and some of these are not explicitly related necessarily to the landlord tenant law or 327C. So I'll just go through those really quick. But Susie, service provider, is asking if a person owns a manufactured home, can they get assistance if they're behind in their lot rent? In general, yes. There are programs out there specifically to help with lot rent. A great place to start is by calling the United Way. They're the place that we usually recommend folks go to see what resources are available to them in their area. We had, and as Matt pointed out, we had several questions about title. Seems that that is a common issue, and that is rather outside the scope of either 327C or the 504B chapters. And then let's see, so that was both Margie and Karen and Casey. And then so Tylisha is asking about rental licenses and manufactured home parks. Do they need to have them?
To be honest, I saw this question and I should have looked into it a bit more. I don't know. Have never seen that issue come up.
I
Sounds like
think they're
Matt might know.
regulated through the Department of Health is who governs manufactured home parks and getting them licensed. I guess I suppose a city could have their own requirements, but I would start at the Department of Health.
Yeah, there are state requirements, but with regards to the city, I'm not actually sure off the top of my head. I don't know if any of the city rental license ordinances would apply to mobile home parks. It's possible some of them do, but every city ordinance is a bit different. So you'd have to know the city, you'd have to go look at their rental license ordinance, and you'd have to see whether it applies, and frankly, sometimes even whether the city thinks it applies, because I'm not sure that every city thinks about that when they put it in. Often people just sort of assume mobile home parks are something else. So the short answer is, I don't know. This was from a tenant, so if they wanted to call or email our office with a more detailed question, I would be happy to look into it. One of the biggest things to know would be the city, because I would need to check their city's ordinance.
Mhm. Gotcha. All right. So Mackenzie, also a tenant, just asked where can we find laws of what landlords can and cannot do? And that's 327C for manufactured home park specifically, and 504B here for general landlord tenant law.
And I would also add that the Minnesota Attorney General has publications, and their publications, particularly on mobile home parks, I think all their publications, at least the ones that we deal with, are good. But I really like their mobile home park or manufactured home park rule change publication, which is only 2 pages, and it covers when landlords can and cannot change the rules very effectively. I send it out to tenants all the time.
Perfect. I'll see if I can get that link here quick. Laura, tenant, you said you had court on the 12th. Give us a call and we will, if you haven't already, and we'll see what we can do to assist you with that. Your questions. Mary is an attorney from, looks like Smurls, had some questions about conditional writs. Samuel, you covered that pretty well initially. So Mary, if you have any
Hopefully.
more, if you
Yeah.
have any more specific questions, like put them in the Q&A and we'll see what we can, what we can come up with there. Okay, and then Giovanna is a tenant and had several questions come through both pre-submitted and at through the Q&A. Obviously, there's a lot of very specific things going on in your situation, so I definitely recommend calling us or emailing us so we can go through your specific issues. But one of the things that I think there's a couple of just general issues that were brought up about privacy on your lot and rent escrows issues. And so I thought that that might be a good both topics to cover real quick, if anyone. So is there any sort of real right to privacy in statute for a tenant when it comes to their lot?
Yes, it's the same statute that applies to residential tenancies elsewhere. So it's 504B.211. The landlord has to give notice. Obviously, a reasonable notice now for leases signed after January 1st, 2024, 24 hours minimum notice. Landlords don't really have a right to come in the home at all. Because if the tenant owns it, again, I keep saying this, but it's worth remembering. We're talking about cases where the tenant owns the home and rents the lot. Landlords don't really have a right to enter the home just at all. But coming on the lot would follow 504B.211. The penalty is $100 or was $100, now $500 for leases signed on or after January 1st of this year. So single violations may not matter. Taking pictures from the street might be allowed. It depends on what they're taking a picture of. There are other privacy laws that apply, or I should say really private causes of action, torts under Minnesota law, like intrusion upon seclusion and publication of private facts that do come up in landlord-tenant situations semi-regularly. These are pretty complicated and they both basically require the landlord to take something private and publish it in a public way that is very harmful. So that could happen, but again, most stuff that is outside and visible from the street, that wouldn't apply anyways. But if they're coming on the lot, they should be giving notice.
As for rent escrows, most of the time those are filed for repair issues. The standard is the landlord needs to keep the property fit for the use intended and in reasonable repair. When it comes to a manufactured home park, what have I seen for that? I've seen like a lot that was graded so poorly that the home like caused a bunch of like flooding. Like that's something, the condition of the lot, that is what the tenant is renting. And so that should be right fit for the use intended. Maybe the roads are torn up and unusable, things like that. Promised amenities aren't being kept up. Those could all be grounds for a rent escrow. 14-day letter, and then you file the case in the court.
Thank you for that. All right, so that was the end of our pre-submitted questions. So then getting into the QA questions. So going back to fees, Gina made a request to talk about to identify fees charged on residents' monthly rent bill and an obligation to provide resident with a receipt for welfare applications. Not entirely 100% certain of what the distinction between welfare applications and just the general requirement to have a receipt specifically entails, but if you could talk about as what sort of requirement that park owners have to, provide receipts for payments and to identify charges, like how those fees are identified for a tenant.
Well, so I also don't understand the second part of the question, which might just be it means it's in an area we're not familiar with,
Hmm.
or maybe there's a way to re-ask it that would clue us into what's being asked there. But as far as ID fees charged on a resident rent or monthly bill, there really aren't that many obligations for a landlord to do that. But as we discussed, there also aren't that many fees that a landlord can charge. It is mostly rent or utilities. There are some requirements with how you disclose utilities. So if it's a specific question about utilities, there might be something there. But in general, I mean, there just aren't that many fees that a tenant should be charged. So I'm not really sure. I guess I'm not really sure in a situation where a tenant would get a bill that things aren't disclosed or where they wouldn't understand where the main thing is coming, unless the landlord is just making stuff up, which does occasionally happen.
Gotcha. All right. Here, Matt. We'll just kind of go back and forth here. Sarah is an attorney, and most of their question was answered before, but I wanted to keep it up here because they also wanted to know, does the lot size need to be specifically defined in the lease?
I think it should be. That's I think that's best business practices, certainly. Um, I guess that's my answer. I think that's a sort of a good question when it comes to what makes a lease, right? And part of a lease is the specific area that you rent. And 123 Main Street, right? We know what that is. Apartment 7, we know what that is. Um, Lot 4. Um, I think that's what I would want if I was signing a lease, is I would want it to say what it is that I'm renting. And I if a lease just said the tenant rents a lot somewhere in the park, oh, that's fishy to me.
Sure. All right.
The actual division of the lots themselves, I think, is added into a plan that the park has to submit to the Department of Health when they get their like authority to run the park.
Mhm.
Um, if that's maybe that's more helpful.
Okay, so at the very least, it's defined when it initially is created, but and
Yeah,
then we go back to our substantial change discussion we had earlier about whether that change or not is substantial.
yeah.
With the classic, it depends probably on the situation
It's
answer.
all I know. It
Sure.
depends. It's all I know, really.
All right. So this is a kind of an eviction related question. Anonymous is wondering, can a manufactured home park landlord refuse to accept rent payments after an eviction has been filed for non-payment?
Yes, they can, and in fact, most of the times they will. The waiver defense or waiver by partial payment defense, both of those can apply in mobile home parks depending upon various factors. So most landlords, to be safe, just refuse to accept all rent once they file an eviction for non-payment. And that again, I would say that's a pretty standard practice, and they are allowed to do it.
All right. Yeah, Natividad says that fences sometimes have to do with spacing. I think that was in response to the lot size changing. You covered a little bit earlier, Samuel, about issues with drugs and
Yeah, so I
imperiling
can go
the
back to
residents.
this.
Hmm.
Um, so I do think I misspoke slightly. The normal requirement is 30 days. For serious endangerment or substantial annoyance, the tenant doesn't have a right to cure. There is the ability for a landlord to file immediately after a second notice or subsequent time after receipt of the notice. I'm not actually sure what the subsequent time means. With meth or something like that, the landlord could try to make an argument, I suppose, that if the tenant is continuing to make meth, cook meth, sell meth, whatever it might be, after receiving the notice, that maybe those new violations allow the landlord to file. Landlords can file expedited evictions for serious endangerment, that type of thing in certain cases, but that wouldn't get them around the prerequisite to give the 30-day notice. So yes, I mean, the short answer is I can imagine a scenario in which the landlord has to give a 30-day notice and wait 30 days before filing an eviction, even when the tenant is selling or cooking meth, or other serious crimes. Now, obviously, with certain crimes, the tenant might end up in jail, and I understand why a park owner would like the person out of the house, and why even their neighbors might. But this is just a situation that you find yourself in lots of places. If you own a home, or if your neighbor owns a home, and they commit a crime, they don't get immediately evicted or lose their home, or the home doesn't go into foreclosure or anything like that. These are often very expensive, tens of thousands of dollars worth of property, and so they have some additional rights enshrined in the state law.
All right, thank you for that. All right. And the TV Dad says that there's an abandonment law for community owners. If you want to provide that number, that would be lovely. Otherwise, it's what we've discussed under 504B, and the conditional rent law stuff that we have discussed already. So I think, Matt, this one was to you for, can a tenant just sell to a park voluntarily?
Yeah, if the
Sure.
park wants to buy, a willing buyer and a willing seller, I think that's fine.
Mm-hmm. And this is again from Tim, who wants to know, just for peace of mind, should a property owner give a 10 or 14-day notice to a non-payment? I'm assuming that is a manufactured home property park owner.
Yeah, so I'll go back to this. I covered it briefly, and I think we also talked about it in greater detail in one of the CLEs or presentations on the rule changes. The distinction here is 327C.09 requires a 10-day notice, but the new law that was just passed requires a 14-day notice. I don't really think there will be that much debate. I haven't seen any cases on this, but under basic canons of construction and statutory law, since the new law is both newer and more specific, I think that in any case where the 14-day notice requires more than the 10-day notice, the 14-day notice kicks in, and the 10-day notice still has to be applied. There's not a lot of overlap, or I should say there's not a lot that the 10-day notice requires that the 14-day doesn't. Everything the 10-day notice requires, the 14-day notice does require, but the one exception is the requirement to give the notice to any party holding a security interest. So there, I think a landlord has to do both. But otherwise, I think it's the 14-day notice and the requirements of 504B 321 subdivision 1A.
All right. Margie, you had asked about where to find the title information. I did put a link real quick in the chat to the Minnesota Department of Vehicle Services. I think that's a reasonable place to start. Okay. Oh, and Gina has given some clarification to their earlier questions.
Okay, I can go back to these.
Yeah.
So landlords are supposed to provide receipts for cash. There's no real requirement to provide receipts that I'm aware of for other types of rent payments. Obviously, many other types of rent payments are sort of self-verifying, like checks, etc. Welfare agencies, they sort of get, in most cases, to decide what they want to require in order to get the assistance. And so there might, in some cases, unfortunately, be a gap where the park owner won't provide what's necessary. Now, the good news is that under the requirement we were just talking about, if the landlord wants to file an eviction for non-payment of rent, they have to give the 14-day notice, and that 14-day notice can be used with that 14-day notice can be used to get emergency assistance from at least certain types of emergency assistances. They would be required to take that 14-day notice. That might not work for all emergency assistance places. For example, I don't know if it would apply to the Salvation Army. It might, I'm just picking one at random, but a lot of county-run emergency assistance places would be required to take that 14-day notice, and that would work. I see then also the question about the rent being 550, but the rent bill is 625. That is a difficult question. I mean, if you just have a lease, and this is one where, I don't want to give legal advice in this specific situation. It sounds like there might be a real person here dealing with this. They're welcome to call our office. We can give them legal advice. But in general, let's say that there is, the landlord says, here's your bill for 650, and the lease says 550. I mean, you try to get an answer from the landlord as to where that $100 comes from, but if they don't, at some point, if you're confident in your reading of the rules, the lease, et cetera, you just say, no, my rent is 550, here it is. You want to file an eviction, we'll go to court and we'll have a trial over what is actually owed. And sometimes that is the only way to resolve it. That's unfortunate and hopefully doesn't happen. Under the new laws, the landlord has to provide a lot more information when they file a court case. So if they did go to that, you'd get more information because they have to file the breakdown of where the fees is. So again, with the pre-eviction notice, they actually have to provide a ledger and a breakdown. So if they're not doing that at the eviction standpoint, or once you get to the eviction itself, there might be more remedies. But prior to the eviction, the landlord's really just going to send a bill out saying 650 when the rent is 550. You ask the landlord, you try to figure out what it is, but if you can't, you say, no, here's, my rent says 550, here's the 550.
Okay. And with that, it is 3 o'clock. We are done with questions. We have skidded in right under the door, grabbing our Indiana Jones hats as we make it through. So thank you everyone for sticking around with us. Thank you very much for Samuel and Matt for giving us all this information. The recording is going to be up on our website in a few days, along with the PDF version of the slides. And again, if you're here for CLE credits, we will be getting that information out to you once we get the numbers. So thank you all again, and I hope you have a great rest of your day. Take care now. Bye-bye.